So a few months ago, RDA announced that we have in-house legal counsel. And here is Gareth. This is the in-house legal counsel. Now, everything legal takes a long time, but we wanted to give the audience an update on what we've been working on, what Gareth has been working on. So most of Gareth's work so far has been in fair work, in the fair work realm. So Gareth, can you just take us through what you've been working on and how it's going?
Yes, so we have been assisting people with fair work, unfair dismissal applications to the Fair Work Commission. So we've been assisting people actually prepare the appropriate form, which is Form F2. We've also then been representing people in directions hearings and conciliation hearings. A conciliation hearing is when you go in to settle the matter. I've represented several different groups of people so far, and as yet we haven't reached settlement, which we all knew would be the case. So there's no surprises there. However, you do get an interesting insight when you go to conciliation about some of the strengths and weaknesses of your position and the other side's position. So it's been a good learning process. We've had a situation where we were made an offer, which was a very bad offer, to be honest. But the people that I was representing, which were 11 people in the same hearing, they were all unanimously decided that it was worth going to a hearing because they thought that we had a good argument, they had a good position, and they were happy with the way things were going. So that's a good positive feedback that we're getting from people that we're assisting. We're now preparing submissions to the New South Wales Industrial Relations Tribunal, the two nurses that I'm representing. So on top of the Fair Work Commission, we'll also assist people in industrial relations tribunals because they're effectively the same. So those submissions will be due within the next couple of weeks. I intend to publish them on the RDA website so everyone can see what we're doing, can see the arguments that we're making, and they may be able to assist you in dealing with your employer. Once we actually get some success, obviously we'll be broadcasting it very loudly, I assure you. But that's going to be a little way off. I think the submissions to the New South Wales Tribunal, for example, will be due in a couple of weeks. The other side then has 6 weeks to respond. We then have 2 weeks to respond to their response. Then you have a hearing, and then you have a decision. So you're talking about a significant amount of time. So I would like everyone to understand that this is a lengthy process and not to let that demoralize you or discourage you from going through the process. Because once you go into the process, there's not much for you to do. You submit the form, you sit back, you wait for 2 months for the conciliation hearing, you show up for an hour, you then sit back and do nothing again for several weeks. And, obviously we're doing some heavy lifting for people, but also others are really doing some heavy lifting themselves. I've had a lot of emails from people who are assisting with a whole heap of information they want to include. That's been really good.
What are people doing during this time? If it takes up to 9 months to get an answer, are these people out of job?
Work. Yeah, you need to go and find other work. Because if you need to find other work to be able to support yourself, you really should, because you're actually expected to. When you are fired, you're essentially arguing a breach of contract claim. And whenever there's a breach of contract, there's an obligation on someone to basically ameliorate the damages, okay? So you're meant to try and limit the exposure that you have. And one way of doing that would be going and finding work. Now, some people have been saying, well, I want reinstatement. The reality is that's very uncommon. Reinstatement is very uncommon. It's also very impractical. If you've been out of a job for 9 months or 6 months, whatever it might be, it's very difficult to go back. For both you and the employer, often they've filled your position, more often than not. And also, after you've gone through a dispute with people, you tend not want to work with them anymore. That's just human nature. You don't want to work together anymore.
So what you're really trying to get is some sort of compensation or a redundancy package. Is that correct?
Yeah. So through the Fair Work Commission, you can get up to 6 months pay. That's the maximum amount of compensation. Realistically, I'm saying to anyone that if you get 3 to 4 months, you'd be mad to not accept that. Now, often it's a lot lower, anywhere between 4 to 8 weeks. But the circumstances we're dealing with are very unique. So I'm not in a position to really say what should be expected. And I think if any lawyer told you what to be expected, I think they'd be lying to you, because no one's ever been through this. This is a completely unique situation. We've never had mandated medical procedures. I personally was in the Defence Force and we needed certain vaccines to be deployed, but it was only to be deployed. If you weren't going to be deployed, it wasn't an issue. So, and you knew that when you signed up. It wasn't just dropped on you at the last minute. And we're talking about things that have been around for 30, 40, 50 years. Very different situation. So this is completely unprecedented, completely unheard of. So no one really knows how this is going to turn out. But I can't stress this enough that it's the fight that is the win. If you sit back and do nothing, if you roll over, walk away with your tail between your legs, you've lost. You have lost.
So even if you are, I mean, you're representing or you're helping up to 50 people at the moment. And
yeah, they're getting close to that now.
And if none of them are successful, will you regret the work that you've done, or do you think it's all part of it?
No, not at all. Not at all. And the reason why I won't regret it is because we are in the right. And I'll say that from a moral point of view, we're in the right. Because this is really a moral issue. It's not a legal one, although it's obviously a legal one, but more importantly, it's a moral issue. And what's being done is very moral. It's wrong from beginning to end. And it's very important that when good people see the wrong thing being done, either to them or others, that they stand up and say something.
Yeah. And it's a ripple effect. You never know. You never know, if you wake up one of the Fair Work, judges or I don't know if they're called commissioners. Yeah. So are you hopeful of a win at any point?
I am hopeful that some employers, and I'll explain why after I say this, that some employers will strike a deal. And the reason why I say this, I've had a situation where I was assisting someone. I won't go into any personal details, but I wrote a few letters for them in response to the back and forward with their employer, which everyone's gone through, I'm assuming. And they were basically sitting at home on unpaid leave. And then all of a sudden they started getting paid again.
Huh.
Right.
Really?
So, yes.
But wait, so they're not working and they're getting paid?
Yeah, so that happened a little while ago. Now, I believe the reason why that happened was because the employer all of a sudden became very uncertain of their position. And if you've got someone sitting at home that's unpaid for a significant amount of time, well, then really you fired that person. They're not going to be employed. And at some point you would have to say that the employer has repudiated the contract, which means they've terminated the contract effectively. Because the part of being employed isn't just that you're on a payroll somewhere, it's that you're getting paid.
Yeah.
So that's the most important part, actually.
Good.
Yeah.
Now, I know that you're working on other matters too, but we're not going to overdo the audience at the moment with what you're working on. One thing at a time. And of course, RDA is providing all of this free of charge, so we can only handle so many.
So many people. So I will only mention one other thing that people should explore themselves, is that I'm assisting 2 people over in WA who are taking a small debts court action against the Deputy Chief Health Officer for denying medical exemptions. And in that process, it's become very clear to me and to the people that have commenced the action that the Deputy Chief Health Officer does not want to face this issue. They don't want to physically show up to the hearings. They don't want to face the issue. They don't want to be held accountable. And I think the reason for that, I think anyone could work out for themselves. I don't think I need to say why. So it's very important that if you're in a position, and I will, with the permission of people that I'm helping, I will publish some information about this for people to use to be able to do the same. But if you're in a position where you've been directly affected by the decisions of a authority, like a public authority, there is a legal concept that everyone can learn on their own. It's quite easy. It's called procedural fairness. And whenever a public authority is making a decision that affects someone, they must afford that person procedural fairness. So part of that is providing reasons for their decision. And also when they review their decision, that they do it properly. So if they rejected a decision for lack of information, that they would let the people know what that information was, which obviously didn't happen in the case that I'm assisting with. So it's very important that if you're in that position, that you either look into this matter yourself and consider taking action directly against the decision maker, which you can do in a lot of different courts. And if you need some assistance, obviously drop us an email and we'll try and help you.
That's awesome.
Definitely in the small debts court, you can do a lot of this yourself because that's what the small debts courts are made for. Same with QCAT and DCAT in Victoria. They are designed for people to use on their own without the assistance of lawyers. which is obviously the best way of dealing with things.
Well, we should probably come up with some template instructions on how people can do that, actually.
Yes.
So
And I think we should publish some information on procedural fairness as well.
yeah,
There's some essays that are actually published on a government website. So they're from an authoritative source, as they like to say, that are very informative, very easy to read, and very easy to understand. So
awesome.
I'll send those over to you shortly.
Yeah. So yeah, anyone who's watching this, yes, we will publish that information, and it will all be available under the resources tab of the Reignite Democracy Australia website. You'll see legal written there. And here we have the instructions on the Fair Work claims, and you can contact us through the contact us section of the website as well. And if you just choose the legal option in the drop down box, that information will go to Gareth. So thanks for the update, Gareth, and we'll be in touch. We'll obviously do this every couple of weeks from now on, so people get informed.
Good to hear. All right. Thanks, Monica. Enjoy your evening.